Hello, I'm William Gamble. I am your guide for the day and talking about in security requirements in line with. Uh, I'm been a lawyer for longer than most of you have been alive, and I also have four certifications in IT, and I teach and train GDPR and ISO 27000 as well as consult. Let's see now, is that going to be annoying? Yes, it will. Okay, this is basically what we do at IT governments. We do all sorts of risk management, protection, training, and all sorts of wonderful things. And if you want to contact our office, they'd be happy to give you more information. Okay, an overview of the current regulatory landscape. Stop right there. The scope of the general data protection regulation. What has happened, if any of you have been looking around recently, is the general data protection or the idea of the GDPR has metastasized. There are over 15 different countries around the world that have similar regulations. There is, of course, the California Consumer Protection Act, which is due to go in 2020. We will no doubt have something in the United States from the federal government fairly soon. So these laws and regulations are already, every 50 state has a breach notification law. There's bio laws in Illinois. So this is nothing that, I mean, if you don't do business in Europe and say, well, it doesn't apply to me, you'd be wrong, because that's not true anymore. All these laws are all over the place. And let me qualify that in two ways. There are two types of laws. There are security laws, and there also are privacy laws. Now, it's possible to have cybersecurity without privacy, but you can't have cybersecurity. So they sort of go hand in hand. Okay, main responsibilities and obligations of controllers or processors. Controllers and processors are two defined roles specifically under the GDPR. Now, there's some statutes like Brazil and potentially India that have sort of swallowed the GDPR, and Qatar, who have swallowed the GDPR whole, that retain these definitions. Others have allude to them, but not exactly. Data breach and incident response management obligations. Well, that's for everybody. I mean, it doesn't matter if you're doing any business anywhere in the United States, anywhere in Europe, anywhere in India, Brazil, like about 10 other Asian countries. You got responsibilities in terms of data incident response management obligations. So you're going to have that. Now, penalties imposed on various types of people will vary enormously according to whose law you happen to violate. I promise you, though, if you have a data breach and you don't report it to somebody, you probably violated somebody's law somewhere. So, you know, it's sort of like Jimmy Buffett. There's got to be 5 o'clock somewhere. All right, how's that working? Okay, I see. All right, now, if we're looking at the data protection, this chart has to do with the GDPR. However, it is useful in terms of a lot of things. First of all, let's notice there are various types of people listed in this chart. We have a data controller. Now, what's a data controller? A data controller is the person who decides the means and the purposes for which they use a data subject's data. Okay, here's the data subject's data. To tell you something that everybody thinks of also, since I just said that, it's about cybersecurity and privacy, but these things are about much, much more. They're about property rights. Whose property rights? We're talking about the data subject's property rights. You see, the GDPR and all these other laws are coming around to defining your property rights in your data. Now, that sounds like a new idea, but the reality is that's been around the United States since for over 120 years now. So that's when it was first proposed, and the concept does exist. So we're talking about these people. Now, these people have rights in what? They have rights in their data. So these people want to use that data. They want to use the property. They want to borrow or rent the property of the data subject. Now, up until now, that's for the most part been sort of free. But what these things do is they say, no, 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 no. You have to make a deal, make a contract with if you're going to use somebody's data, you have to make a contract with the data subject. And you see, that's where it comes in. That's where the duties come in. So that's sort of what they're saying is if you use somebody else's data, you have certain responsibility to that person. And in terms of how you use it, how long you have it, things like this. Now, over here is another individual. That's sort of a contractor for this person. All right. Now notice there's no between the data processor and the data subject, because the data processor's contract is with the data controller. They owe the duty only to this person. Now, there are also other types of people involved here. So there are third countries and third parties. Now, we'll get to that at some point in time. Now, up here is the enforcement agency. Here it says Information Commissioner's Office. That happens only if you're in the UK. There's the European Data Protection Board. But, you know, if you want to, you could substitute a whole bunch of other people for this. I mean, if you're in healthcare, you could subject, in the United States, you could call that the Office of Civil Rights, which enforces HIPAA. If you're a financial organization in the state of New York, you could call that organization the New York Department of Financial Services. And a lot of these things would be very similar. So let's say if you're in New York and you know you're under the New York laws of the New York Department of Financial Services, this person would basically be a bank, and these people would be sort of like customers. But the bank still owes duties to its customers under just that statute. Or let's say this is a hospital, they still owe duties to the patient. Or they might outsource some of the stuff out here to the cloud. So yes, it says GDPR, but these concepts and the concepts of property have exist sort of everywhere, wherever you're basically doing business. Okay, now under the GDPR, here are those basic property rights. Now these are the GDPR property rights. Now these properties aren't universal. Okay, so all these rights are not universal, but a lot of them are. So I'm going to jump through them. So they basically have 8 rights here. They have information. You have to notify when you borrow somebody's information, when you collect information, you have to notify those data subjects as to what information you're collecting and why. All right, that's a big, that right there is a big one under the California Consumer Privacy Act. They require you, if you're gathering information, to have a big red button on your website that says, I'm collecting information. Now, the GDPR doesn't go that far, but it's very specific about that. I have not seen a statute. Now, there are certain requirements in the United States for privacy under HIPAA, and if you're gathering information from children, you have those obligations. So that right of information is not limited to the GDPR. Access, now that's a real biggie. Now under the GDPR, you have what's called a subject access requirement. The data subject, or the person you borrow the data from, has a right to see what data you got. Now that one is all over the place. So some laws have it, but most do. Most allow you for the data subject to see what information you collect, if you collect any information. Rectification, that is the right of the data subject to change and make sure you got the right information. Now that is a right, but frankly, that helps everybody. You don't want to be sending emails to the wrong address. You don't want to be all that. It's just annoying. So hopefully everybody has, the best way to do that is have a portal and allow people to correct their own information and update it. The interesting thing about that is most websites I deal with anyway usually have that anyway. That just happens to be a right. Erasure. Now right under the GDPR, the right to have any company who's got your information get rid of it, just wipe you out. Now that's limited under the GDPR, but other statutes, it's unlimited. So anybody can erase stuff. Now, how that affects you is you have to be able to erase all, evidence. So basically, how that's going to affect markets is we're going to probably see the end of tapes and probably the rise of solid state memory systems. Restrictions, objections, and data portability are sort of limited to the GDPR. Restriction is you have a right to restrict how someone uses your stuff. You have the right to object, and you have the data portability. In other words, you can move your stuff around all over the place, which is really an antitrust sort of concept. And be informed of automated decision making, like if you're going to use my credit score or something like that, and you're going to deny me a loan because of a FICO score, and no human's going to be involved with that. That's very, very limited to the Europeans. Now, also the enforcement mechanisms change all over the place. Some, like in the United States, there are some. It's limited just to the Attorney General has a right to enforce the law. Here's the right to lodge a complaint. Now, anybody anywhere can lodge a complaint. The question is, are there any other enforcement rights? Like, can you go to court? And that varies according to the law and the jurisdiction in which you're in. Many, many jurisdictions do have that. So in addition to the regulators enforcing this, you also have the ability of the data subject to enforce it. Okay, it applies to controllers and processor. Yes. Okay, however, the point about apply to controllers and process, irrespective of where the processing takes place. Now, what does that mean? Okay, in other words, that means that if you come within the jurisdiction of the EU, which means you're selling stuff to Europeans, then you come within the jurisdiction of the statute. Now, jurisdiction is a tricky thing. So all these statutes have different jurisdiction process. Many of them use this one. So like if you're selling stuff to Japan, they have a similar type of processing requirement. In Taiwan, for example, their processing is very similar to that, except you can't process in China, which sort of makes sense. So if you're offering goods or services to the jurisdiction where you may be part of that. You may be subject to that regulation. So you have to determine, first of all, where you're selling stuff, and determine whether or not it's directed at that person. I mean, if you have a website in English, you're not necessarily selling stuff to the EU, so it doesn't apply to everybody. However, you may be subject to some other regulation someplace else. So don't just assume I'm not selling stuff to Europe that you're out of regulation. The reality is you're not. All right, if you're in business somewhere and you're collecting data from people, there's probably some sort of regulation out there that affects what you're going to do. All right, these are all the rights. All right, now it's up to you. You can say controller, but I'm going to say the person who collects the data, because controller doesn't exist everywhere, to make sure everybody has these rights. Right to be informed, all the 8 rights here. Okay. However, the top 4 up there are all over the place. So you have to be, and if you're collecting data from somebody, you have to look at what we call in the ISO world as your context. You have to look at what laws you're subject to, and it's a good idea to have a list, and then comply with that if you're collecting information from people. And wherever you're collecting information, if you're collecting, because the world's a global place, and hopefully all of you take advantage of that. So you're going to have to figure out where you're collecting information from and be able to comply with the law of that jurisdiction. Now, in GDPR, let's look at a data controller. All right, we're going to call a data controller the person who's collecting the information. The legal basis for collecting the data. Now, that one exists. That's getting pretty usual verb, so they don't call it that. They just say, for example, many of the laws require consent before you collect your information. Well, they don't say legal basis, but they say you can't do it unless you have, or you don't have legal basis in that particular business. Which items are personal data, the content of the data. It's probably a pretty good idea to tell that, because there's all sorts of funnies out there, like sensitive information that it may not be a good idea for you or anybody else to collect. So you have to be very purpose or purposes for which the data is used. That's very specific on the GDPR, and Articles 13, 14 basically are the notice provisions, but there are all sorts of privacy notice. For example, you might not be aware of this, but there's something in the United States called the Federal Trade Commission, the FTC. Now, the FTC isn't going to prosecute you unless you say, I'm collecting your data to use for this purpose, and then you use it for something else. And you don't say that, all right? Well, that's an unfair and deceptive trade practice, and that could get you in big trouble in the United States. Now, who has it gotten into big trouble? Oh, let's think about that. Facebook and Google are both under consent decrees for multi-million-dollar fines, which they're trying. And the reason is they said they were collecting data for one purpose, and they were using that data for something else. So yeah, okay, that's neat. It's in the GDPR, and that's true, but it's also in the United States if you're doing business here. Which individuals to collect data about? Well, you have to be very careful, because you don't want to collect data about somebody. There's a somebody out there. I'm not going to get into some of the licentious elements of the case, but he might be remembered Hulk Hogan. Well, somebody collected data about him, which was a little racy, and used it inappropriately, and that resulted in a $114 million judgment. So you have to be very careful about. I'm sure most of you won't go that far, but you have to be careful about how you do it. And by the way, that happened in Florida. It didn't happen, in France. Whether to disclose the data, and if so, to whom. You have all sorts of obligations in regard to in New York for banks, for healthcare organizations. About, you have to be very, very careful about who you disclose data to if you collect it. So that's important. And again, that's not just in Europe, but that is true. It does exist through the GDPR. Whether data subject access rights apply. Well, again, yes, in Europe, you have the right to go and look at all your data. Now, that might not exist right now, but it sure will exist in California after January 1, 2020, which is a little over a year away. So, and that's going to affect everybody else, because you have to remember that California has 12% of our gross domestic product. How long to retain the data to wait, or whether to make a non-routine amendment? Well, that's very important. But the reality of that is that you shouldn't want to keep data forever. Why? Because you're costing yourself money to keep it forever. Now, under the GDPR, you can only keep it as long as for the purpose you told people. So, or if there's another legal reason, like you need tax data or employment data or something like that, so you have to keep it for 7 years. But if you're retaining data, remember, by storing data forever, you are, it's money. And you have to remember that, in Iron Mountain, for example, as one of my delegates told me, only 10% of what goes in ever comes out. So think long and hard about your need to retain what data, because it's not only a potential requirement under the GDPR and similar privacy laws, it's also costing you money that you may not have to spend. Okay, here is controller. Now remember, I'm going to talk about controller, somebody who collects information. Now that's labeled the controller, or the GDPR, maybe labeled something else, depending where you are. I'm not sure what in Russia don't have any laws like that, but I'm not sure what they call it in Japan, but I'm sure there is a word for it. Okay, the controller does have generally a lot of these similar requirements. They have to implement data protection. That's the big one, all right? Because if you've got somebody else's property In other words, if you have their data on your system, you have the requirement to protect it. Now, so far in the United States, you're sort of, because of the case law is that you're sort of insulated from a lot of that, because a lot of these people, if you lose their data, you may not have any liability to them because they haven't had any losses because someone else, like MasterCard or the bank, is picking up the tab. All right, but if they do have a loss, then that loss could be, quite spectacular. Now, there are others right now. Also, we just had a new law passed by Ohio, and they will, if you have a cybersecurity framework like ISO 27000, and that's the only framework you can certify to, is if you have certification to that a framework, that's a safe harbor. You can choose another framework, but if you get sued, you're going to have to go into court and prove you have that certification. You have to implement technical and organizational measures. Well, that's not absolutely required under all laws. It's required in New York. It's required for hospitals. It's required for other types of things. So it is required under the GDPR. Adhere to codes of conduct. Well, right now there aren't any codes of conduct, but it's probably a good idea to come up with some sort of cybersecurity framework, preferably one that you can certify to, so you don't have to prove, not to necessarily your customers, but because you're part of whether you like it or not, you're part of a global digital supply chain, and you have to prove to your customers and partners that you're cyber secure, and there's only one certification to do that. Okay, Article 28. That's okay. Now we have this new dramatis personae, a processor. What is a processor? A processor is somebody who basically processes your information, but hopefully has no contact. Under the definition is they will determine the purposes and means for which the data is controlled. So what we're really talking about in these days, it could be anything, but generally it's a cloud. All right, the point of what the GDPR states is something you ought to do anyway. You should have a contract. You should have a very specific contract between whoever collects the information, and hopefully that's most of your businesses, and whoever's processing that stuff. Now, what the GDPR does is basically provides you with a checklist of what has to go into the process. And the point about this is, okay, all right, I don't do business in Europe. Well, still, it's a good checklist. So this is something that you should be able to think about, because it may come into something else. For example, assist the controller by appropriate technical organization. Assist controller to ensure assists the controller in ensuring compliance with obligations to security or processing. Well, if God forbid something happens and there's a hack or a breach somewhere, which, because most of the breaches are like 58% are due to human error, there is always a possibility that there's going to be a breach. Okay, if there's a breach, what happens in that case? Well, you got to tell somebody. And you come into all sorts of problems. The worst case scenario is, let me think about Yahoo, where they had a breach and they didn't tell anybody. They didn't, they had obligations, but they didn't tell anybody. Anyway, that was, and so they got whacked under a cybersecurity law. No, they got whacked under a securities law. So what happened is they got hit by the SEC with a minor $25 million fine because they didn't report the fact that there was a breach. So you have to assist in ensuring obligation and make sure that these people help you in complying with any sort of law. So they only process information according to your instructions, which should be in their name. They make sure that persons authorized has confidentiality. You want to keep privacy. Take appropriate security measures. Every cloud probably is far better at that than you are. Respects the conditions for engaging. In other words, tells you if there's another partner in their digital supply chain. Technical organizational measures to make sure the thing works. Deletes or personal data control at the end of a, well, that's a good idea anyway. You don't want any, the problem is you don't want to leave everything. The problem with these things is once you provide the information there, it can stay there forever. So you have to make sure that in your process, you have the power to delete the information, especially appropriate if you're talking about sensitive information. Now, regardless of what the jurisdiction is, you're going to want that anyway. So this is sort of a nice way. Make available all information to demonstrate compliance. Don't forget the with the regulation, with any regulation. So that's a good idea to, and the big cloud providers are, especially Microsoft, are very big, and they already have lots of stuff that available to help you with all these requirements. Okay. Records of processing activities. The controller of records shall maintain a record of processing. Okay, now this, yes, the records of processing in Article 30 is limited to the GDPR, but these types of things are types of things that show up in many of these laws, and they might be required for different types of purposes. So it's probably a good idea to try to figure out what data you're holding. I mean, that should definitely go into your risk assessment. And these days, one thing that is totally common, as a common denominator about all these laws, and it's about common denominator about cybersecurity in general, is what we're talking about right now is before you even think about your cybersecurity, you got to think about your risk assessment. All right? You got to figure out, I mean, is the data I hold, is it wildly valuable? Is it personal, details, financial details, health details, political opinion, all that, really touchy stuff that people will go, insane if it's breached or has enormous value, like anything a law firm holds, anything has enormous value, in the dark web. So you have to consider, first of all, what assets you control. Now, if these assets, or it could be just B2B, which everybody knows anyway. So don't worry about that. But you have to figure out what assets you hold. And this is where the records of processing activity become vitally important for anybody doing business in Europe, but for anybody doing business, anybody thinking about cybersecurity, you start with risk assessment. All these laws now, NYDFS, HIPAA, they all have requirements for risk assessment. So this is vitally important. Now, this is of course this is specific for the GDPR. You have to get this, general categories of information, but that's important too, because you have to know the purpose of the category. Look at this description of the categories of the data subject and the categories of personal data. Well, okay, fine, that's the GDPR stuff, but you got to figure out the categories of information, so you figure out what information you have. You have to do a risk assessment. Do you need, all sorts of heavy-duty hardware? Do you have to encrypt everything? You need a cloud application security broker. Is this everything and its brother have to be encrypted, or who cares? So before you budget for your cybersecurity, you have to think about these things. Yes, this does have to do with GDPR, but it's more important in terms of international transfers of personal data. There's the rub. Okay, this is why the GDPR metastasized so quickly. Under Article 44, it says, "Thou shalt not transfer data outside of the country unless," wait for it, "unless the country you're transferring to is adequate." Well, how do you become adequate? Well, you pass a law that looks like the GDPR. Now, guess what happened? Everybody passed laws except the United States that look sort of like the GDPR. So that one has become a big factor in terms of changing the international landscape. I've been doing this a long time. I have never seen laws change so fast. I mean, like there are laws in the United States, like the securities laws, that are exactly the same in many countries, but quite often it took 40 years. This took 4 months. So, and I'm sure the process is still moving along, as all these countries, who have to comply. They want to trade with Europe, and the United States doesn't have any requirements, so they just said, okay, well, we'll go with the European requirement. So that's one of the things, and that's one of the things you'll have to figure out about what you do with the information. Are you going to transfer it? Then there are countries like China that are very, very strict, depending on what you do in China, if you even transfer anything out of the country. So you have to think about what you have to go back. You have to think about what data do you hold? What are you going to do with it? How long are you going to keep it? Who does it belong to? How sensitive it is? This is basic stuff, regardless of where you are. And by the way, it's required under the GDPR and many others. Okay, now these are the principles under the GDPR, the 6 principles, which is I call them LLAARS: lawfully, legitimate, adequate, accurate, retained, and maintained security. The big one, of course, is this one: maintain security. Now that one is almost universal these days, because there are requirements everywhere that say you have to maintain security. In the United States, if for nothing else, that's under old common law negligence. Now, under all the other regulations, it's definitely a requirement. We talk about retained only for as long as necessary. Well, if you don't need it, don't keep it, because it's costing you money, and it could be a liability. I mean, let's say, for example, you're in the United States and you've got terabytes of information somewhere, and somebody, God forbid, somebody sues you, and under federal rules of civil procedure, I believe it's 27, hits you with a discovery request for e-discovery. That's big money. That's like $1 million. I mean, it's just depending on how much it is at stake. But it would cost an enormous amount of money to go through all that junk. So not only are you paying for extra data storage and the cloud or something like that, but you're opening yourself for a potentially enormous lawsuit. So yes, retained only for as long as necessary is a principle under the GDPR. But it's a good idea. You ought to think about it. Accurate. All right. Well, yeah. I mean, if you're dealing with your customers or partners or anybody else, of course you want your information to be accurate. I mean, because if it's not accurate, it's sort of worthless. Okay, adequate and relevant to what is necessary. That is sort of specifically GDPR, because all they're saying is that if it's not, if you're selling me shoes, you don't need my birthday. Or something like that. So don't go crazy in asking over everything. Collected for a specific legitimate purpose. That usually comes down to saying, which is in the United States under the FTC, if you say you're going to do X with it, don't do Y. So that's legitimate purpose. Now that has shown up in tons of different laws. Process lawfully and in a fairly transparent manner. Now, under the GDPR, there are 6 ways you can process lawfully, and the first one is the most famous. It's consent, and that requirement is all over the place. So don't go out. I mean, make sure you ask people permission before you get to use their property. And their data now, almost everywhere, is their property and has been for a long time. You just got to be able to use it. You were fortunate to use it for free until now. All right, now here's the big one: data breach reporting responsibilities. All right, everywhere. It doesn't matter if you're in the United States, in the EU, in Japan, in India, Brazil, Qatar, I think Bahrain and Kenya now. It doesn't matter where you are. If you've got a data breach, you're probably gonna have to tell somebody. Now, there's a big difference under, we define, and there's a difference between what a data breach is. You can quibble over that. I mean, is it what they call an event, which is something that might be interesting, or is it an incident which has a high probability of resulting in the unlawful destruction, loss, alteration, or whatever? Whatever it is, you make sure you're going to have good policies and procedures to make sure that you can respond to this, and that's exceptionally important. You place and ready to go, because under the United States, if you're doing business around the U.S., you're going to have to maybe notify at least potentially 50 attorney generals. If you're in healthcare, you got to notify, depending on the area. If you're in a business in New York, if you're a financial firm, you got problems there. Probably, I'm not exactly quite sure. I don't remember what the California law requires, but most of these other laws, the European law, of course, requires you to do it in 72 hours. And they have to all report data breaches. Fairly straightforward process, and right now everyone realizes, the regulators realize that you will have data breaches. So it might require investigation. It really depends how stupid you are. For example, under the healthcare laws in the United States, most of the breaches are because someone left a computer with unencrypted healthcare data on it in the cab or something and lost it. So you really have to think. It's the point about all this is it's a good idea to go back in the beginning and think about how you do cybersecurity. And that's where, the frameworks like the NIST, which is required of all federal government agencies these days, that the NIST cybersecurity framework or ISO 27000, they require you to come up with a system, a process, which would include a process for breach notification. And the big thing about cybersecurity is training. So what you want to do is you want to train people to get ready for a personal data breach, because it's going to happen to you, because it happens to everybody. All right, it's just, the fickle finger of fate has not just pointed you out because you're unlucky today. It sort of goes out against everybody, because the hackers are not some kid in their parents' basement in a hoodie. They're organized, well-equipped, brilliant, people who are do this internationally on a vast scale, and it's going to include you, even small businesses. So be ready and have that ready and have a procedure and process in place, because it's going to happen to your organization. All right, data controller must notify the supervisory authority. Okay, this is the law. This duty is in the law, and the notification without delay and not later than 72 hours. All right, this is the GDPR law. All right, well, they're a little draconian. It's 72 hours. Depending on the state, it could be a lot longer. It could be months. But every United States, every state has one, and most other countries also have these things. So you have to what the point of this of the data breach responsibilities is, yes, it's yours, and number one, and yes, number two, you have to have a procedure for reporting these. Now, this is what the Europeans require this. Okay, they say unnecessary in certain circumstances. Okay, that by the way is a biggie, because one of the best get out of regulation free cards, which is almost universal, is to encrypt everything. The more encryption, the better, basically. But if you have a breach, you have to be able to respond to these things. And so you're going to have to, you have to catalog where what your context is, I don't know, your different companies, and figure that one out and notify the appropriate parties. Now, in the EU, that's a regulator that's known as a supervisory authority, or if you're really cool and do this a lot, we call them SAs. But in the United States, it could be an attorney general. It could be the New York Department of Financial Services. It could be, whatever regulation. In Korea, they have regulators. In Singapore, they've had that law. They've had a privacy law since 2010. And excuse me, they do enforce it. I was just reading a case about the fact that they require policies and procedures similar to a cybersecurity framework like ISO 27000. And they were enforcing it against a big company? No, they were enforcing it against a hairdresser and a moving company. So, there are regulators out there, I mean, the Asian regulators are really quite often not known for their uh, for how well they enforce laws, but there are exceptions, specifically Singapore. So watch out for these things. It really depends on where you're doing business and what you're doing. So that will depend. But but don't think, oh, we don't do business in Europe, that it doesn't affect us. Yeah, it does affect you. So it's everybody. Breach report, obligation of the controller to communicate. Now, again, the controller is a GDPR word. We're going to talk about anybody who collects data from individuals, who uses data for whatever reason you may use it. Communication of the data subject. Well, again, that depends. Depends on what you're doing and where you're doing it. You need that list, and then look at communication in clear, plain language. Well, you really should start to speak whatever language you speak well, and be able to put it in on, in something that somebody can read, and stop with the if you have lawyers, there's a certain book, give them English as a second language for lawyers. It would really help. Supervisory authority may compel communication with the data center. Well, yes, but under state laws, there are all different types of things. Usually in the United States, it's a numerical threshold. You have to communicate with everybody if it's like over 500. And yes, there are appropriate, there are exemptions. So, but those exemptions change. So depending on what your context is, you will go down that checklist. The point of this is, see on all this, the point of the slide is that it exists everywhere. So look at whatever your contexts are, and then determine in what is required, and that goes back to your plan. That goes back to your management system. You have to be able to manage your cybersecurity. That does not mean go down a checklist. That means a management system, or doesn't matter if it's a cybersecurity framework or and one of the ISO products. It's just you have to be able to do that, and to be able to get that reporting out, or you're going to be in violation of some laws somewhere. Take appropriate technical and organizational measures to manage risks to secure these networks. Now, yeah, right. I know you guys have really great firewalls, and you've got your SIMs, and you've got your data prevention loss, and you're using artificial intelligence to make sure that all your apps are doing things they're supposed to do. And then what happens? Somebody in your cleaning crew puts a thumb drive in your computer. It's something you're not going to think of, because these people are that good. And so taking appropriate technical organizations means not just having really good hardware, or having the latest app, or having the best SIM, or whatever you got, because it may have occurred in some other way. So make sure you consider the entire manage the risk and security to networks. Well, what's a network these days? I mean, your network is all virtualized. So are you talking about Dockers, containers, and working with your vSphere? You have to consider the entire system, and remember, these things change. The one thing that you're going to be absolutely certain of in this business is that the laws are going to change. Right now, I mean, with the new Congress coming in, we're going to see some, stuff, and it's bipartisan, because the Senate right now is looking into privacy and a federal breach reporting process. So that's something you've got to keep heads up. Watch this space, because I'm sure I'm going to be talking about it over time, and this is going to involve all of you. Okay, now, administrative fines. This is what got everybody hot under the collar. With the GDPR. They went screaming into the night, oh my God, we're going to add 2% of our global revenue. We're going to get 4%. Isn't this terrible? We're going to wipe us up. Well, this is a large amount. I mean, 20 million euros is not chump change. However, compared to some of the U.S. fines, it's pretty small. I mean, we're seeing. I mean, the cost. For example, let's look at Equifax. They forgot to, appropriate segregate the system. They had a server that wasn't appropriately patched. And that's the reason why somebody was able to take advantage of the struts liability. And how much did it cost them? Oh, $300 million and climbing. Let's look at the Maersk, global shipping giant. They're up to 300 million because they installed a accounting program in their Odessa office that fell prey to a Russian state-sponsored attack. And that probably cost globally, the estimates are in the billions. So yeah, these are big fines, but they could be potentially much larger depending on the litigation. The California Act, that charges, it may be $100 a incident. All right, but I mean, if you've lost 1 million records, that's 100 million bucks right there. That looks like make 20 million euros look like chump change. So I can't see that the problem is that this is a severe problem for the world, is that we all, your data is not ancillary to your business anymore. Your data is your business. So yes, it's a support service, a supporting function, but it's crucial. And everybody is a little tired of all their junk being stolen, and it is their junk. And your job, since you borrowed it and you're using it, is to protect it. So you're going to have to come up with different and better ways to do that. So yes, there's these cool administrative fines with the GDPR, but that might be, we may not be talking about anything, but even worse, any sort of breach, like somebody loses a file or something like that, costs your firm money, and it adds up in terms of employee time. Even if you haven't lost somebody else's stuff, you cost your firm a lot of money by not doing this properly. So the better way to do it is, yeah, you should worry about the fine, but what you really should worry about is the efficient operation and organization of your cybersecurity process. Staff training and wearing. I mean, this is where it really begins. You have to make sure that your staff is ready to deal with all this type of thing, because they're the weak link in the entire chain, is to make sure your staff is ready to do this, especially with reporting procedures, because they have to know what an incident is, what an event is, who they should talk to, and that's part of training and that's part of your procedure. And that's very, very important. Yeah, ensure all staff are fully aware of regulations, corporate compliance. Well, just throw out regulation and put, your compliance requirement, because everybody now has compliance requirements and staff have to be adequately trained, because that's always the way that people get hacked. Remember, professionals, as amateurs hack technologies, professionals hack people. And the biggest, according to the FBI, the biggest hack right now is the Beck attack, the business email compromise. Now, the best way to deal with that is with some more training. So that's absolutely implementing staff awareness program. Look at where the problems are. Make sure you use a mix of different focused learning. Well, yeah, you need different focused learning tools for everybody. Make sure that you also make sure they're aware of the problem, and then there are various innovative ways to do it. So you can gamify the whole thing, make it a competition. Give a prize like a penguin. So that type of thing that you can do. Identify risk. What's this all about? Risk assessment. All right. Figure out what your risk assessment. Start. Year one. Ensure continual monitoring of progress. The whole idea goes back to quality control. Why did the Japanese do great with their cars? Quality control, because they adopted a quality control, and that applies to cybersecurity just like everything else. Okay, Article 32 specifically organization to take requires an organization to take as appropriate to take the required cybersecurity. They want to ensure ongoing, CIA and resilience. Well, everybody should do that. That's nothing. That's nothing new. Yeah. The GDPR does require it, but probably it's going to be required eventually in your law pretty soon, or it's going to be required by your customers and partners, because the statistics are that if people don't trust you with their data, they don't trust you with their product. So you have to make sure, or you're going to just basically lose business. Okay, this is what we do. We do all sorts of stuff. We give certified foundation training courses for the GDPR, and I personally teach all these things, and it's an interesting learning experience because I learn enormous amounts by doing these types of things every day. ISO 27000, well, what's the advantage of that? Well, the main advantage of ISO 27000 in terms of cybersecurity is that it's internationally recognized, but the big one is the only one you can certify to. So say, for example, you get sued, in Ohio, and you want to come within their safe harbor, and you have said, okay, I've adopted the NIST cybersecurity framework. Well, that's great. I mean, there's nothing wrong with that. It's a great framework. The problem is you can't certify that. So what will happen is you're going to have to prove in court that you have adequately implemented NIST cybersecurity framework. And that will mean a battle of the experts. So they'll call, the plaintiff will call an expert, and they'll say, no, you didn't. And you'll call an expert and say, yes, I did. And so it's depending on who the jury believes in that case. The advantage for the ISO business is you can say, well, here's my certification. I get audited every 3 years. I got surveillance audit, I got internal audit, I got audited. So that's sort of, here's my piece of paper. End of story. Then you're probably you get a motion to dismiss at that point, and you'll be out of court. The second advantage of that is that it's an international certification. Now, your digital supply chain, it's not just the product supply chain these days, because you got a digital supply chain that involves that goes all around the world. And if your partners and your customers don't trust you, you could have a lot of questionnaires to fill out. This way, it doesn't matter because everybody is operating to the same number. The great thing also about that family is that if you don't know how to do something, ISO will tell you how to do it step by step. So, and we train people for these courses, and the GDPR is if you're doing business in Europe, it's absolutely essential. And eventually we will hopefully come up with products that deal with this on more of a global basis. Okay. Now this is the various types of stuff, obviously, that we sell in terms of this one. By the way, implementing ISO 22301 is the business continuity management. Now, you may think, oh, why do we have problems with business continuity management? Well, I mean, if you've been in the U.S. recently, if you notice that we're having a hell of a lot of 1,000-year storms. So, even if you don't worry about cybersecurity, just worry about the weather, and because you're going to have to. That's something that you're definitely going to have to consider if you want to stay in business. Because most firms, if they don't have a plan for business continuity management, after a major disaster, they may not be in business. So it's like incident response management. It's a lot better to think about it now than after the event occurs. That's a type of insurance. Okay, this is what we do, and also we have all sorts of seminars and stuff like that. Okay, so I get to shut up, and you guys, if you have any, get to ask questions, whatever they shall be. If I can figure out where to find them, then feel free to ask questions. I will be quiet for several minutes. We don't have much more time anymore, so I'll be quiet, and you guys can think of questions to ask. Also, remember that if we give a survey at the end of this, and if you fill out the survey, you get a 10% discount on all GDPR products. Sorry about that. Anyway, so if you fill out the survey information, that you can use that to advantage if you want to buy any of the products that I I actually, honestly, I know all these books because I've gone over them line by line in most cases, and they're all exceptionally helpful, as are various other aspects for any sort of compliance issues. And I'm afraid all of you do have compliance issues. Okay, well, thankfully, apparently there are no questions. So all of you are experts on international compliance with cybersecurity and privacy laws and cybersecurity frameworks, which is wonderful. And I would wish you that you would good luck with your cybersecurity and privacy journey. And if IT governance can be a help in any of the organizations to help you work it out, feel free to ask and find out what we can do, how we can work together with you to solve what any specific products you may have. All right, that's about all I have. So I will sign off, and I hope you all will have a lovely afternoon. And thank you very much for attending.